Several other types of responses include cross complaints, where you file a case back against the plaintiff or another party about the very same issue in the current case, and joinder, which makes another person a party in the case. This can be anyone who has a stake in the outcome of the case. Again, looking at our case process chart, we're going to continue talking about the case process, picking up with the Case Management Conference. The Case Management Conference is a time when the lawyers and the judge, as well as the parties, meet to talk about how they want to handle the case in court. Keep in mind that both parties must appear at the Case Management Conference, either in person or by telephone. The next step in the case process can include law and motion. Motions are written requests of the judge to make orders while the case is pending. If motions come up in your case, you can look at the resources listed for more help. Anytime law in motion comes up in your case, you're going to want to keep in mind some special considerations. First, any law in motion paperwork needs to be in the proper form, including a declaration of facts under penalty of perjury, legal authority, and a memorandum of points and authorities, and other documentation supporting it. Anytime a motion is filed, a hearing date will be set by the court, and the motion will need to be served at least 16 days before the hearing. Before your hearing, you may be able to check the tentative ruling on your court's website. Anytime a motion is brought up, sanctions are a possible outcome. The winning party on a motion may ask the other party to pay for his or her costs and/or attorney's fees in the motion. As well, if an order is made after a motion, failing to comply with those court orders can result in monetary sanctions or result in having your case dismissed. The next phase in the case flow is discovery. This is when you're building your case by investigating facts and discovering information. There are many ways to investigate your case, including taking photos, conducting interviews, and recording data. There are also many free and low-cost ways to gather information. Everything that you gather is called evidence, and the process of gathering that evidence is called discovery. There are specific forms of discovery, or types of discovery, including depositions, interrogatories, demands to look at papers, things, or places, physical or mental examinations of a person, requests for admissions of fact or opinion, or application of law to fact, or authenticity of a document, sharing information about expert witnesses, and their expected testimony is also included in discovery. While you're conducting discovery, if you have trouble getting the other party to produce or turn over or give you the evidence you need, there are several ways you can get the evidence. One is a particular type of motion that can be filed, called a motion to compel. Another option is using a subpoena to order the documents to be given to you. Keep in mind that discovery has very strict rules, and if those rules are not followed, the evidence that you gathered may not be admitted or usable in court, and sanctions can be imposed on you. As well, Remember that getting into discovery can be complicated and expensive. The next phase in your case will be the trial phase. The purpose of a trial is to give both parties a chance to present the evidence they've gathered that supports their argument to a judge or a jury. Before your trial, you will have a date to set your trial date. This can occur at the case management conference or any proceeding thereafter. The court is going to take into account a variety of factors in setting your court date. At your trial setting date, you will need to decide whether you are going to have a jury or bench trial, which we will talk about in a moment. Before your trial, you will need to do some trial preparation. You want to try to begin preparing at least 100 days before your trial. Preparing for trial is difficult and it can be expensive, so this is a very good time to consider settling your case. If needed, as trial preparation, you can go back and look at some of the initial paperwork that was filed, refer to your discovery, arrange for witness testimonies, and prepare your notes and outlines for the trial. Prior to your trial, you will have a mandatory settlement conference. This is when the parties, their attorneys, and the judge meet to try to settle the case. It will typically be conducted by a temporary judge, a different judge than the one who will be overseeing your trial. That judge will help the parties try to come to a solution. If they can agree, the trial will be off calendar or canceled. If not, the parties will proceed to trial. The next phase of your case will be the trial itself. If you have elected to have a jury trial, it will begin with voir dire, or jury selection, where each party will ask the jurors questions to see if they can be fair and impartial. Keep in mind that whoever chose to have a jury trial will need to pay jury fees to those jurors each day before the trial begins for every day of the trial. Once jury selection is completed, or if you have elected to have a bench trial in front of just a judge without a jury, the case in chief will then begin. The case begins with each party giving their opening statements. Each party will then provide witness testimony and cross-examine other witnesses. Each party will then give closing arguments, and if it is a jury trial, they will give jury instructions, and the jury will go and deliberate to reach a verdict. Keep in mind that this entire case process that we have talked about is much faster and simpler in small claims court.